My lord, I have cited DS Nakara, but my lord, your lordships may consider, my lord, for the time being, my lord, not, my lord, read that. Please come to, my lord, page 35. My lord, your lordships are aware, my lord, like which, my lord, we assisted your lordships on the ground of another article where you have to give a declaration that this act is enacted in pursuance to so and so. The same is with 39. The act stipulates, my lord, that we are exercising, the parliament is exercising powers under 39 B or C as the case may be. My lord, I have just, my lord, given a table of several legislations where they have, the parliament has used and mentioned 39B. And my lord, please see the fourth column, material resource, my lord, which is sought to be regulated or distributed, my lord, under 39B. I'm not reading it. I'll just read, my lord, what are the material resources for which. My lord, my lord, I must add one thing. My lord, this declaration, the way in which, my lord, your lordships have seen, my lord, in other cases, my lord, of alcohol industries, etc., is not mandatory in case of Article 39B. But even if an enactment is not mentioning 39B, the government can defend it on the ground that I seek protection of 39B and therefore 31C. Yes, my lord,
It doesn't say industry, the control of which is declared by
is
Parliament.
declared by the, because the constitution requires a declaration. Here the constitution doesn't require the declaration. Lord, liquefied petroleum gas, crude oil, railway wagons and other goods essential to the need of railways. Then, my lord, 5 components of rolling stock like vacuum brake equipments, ejectors, steam brake valves, etc., etc. Some pharmaceuticals and chemicals, tractors, coke oven plants. Lord, some of them are repealed, some of them are in force, but that's not relevant. I'm just giving an illustration that these are the material resources for which the parliament did, my lord, take into account and mention 39B. Anglo-French Textile Limited, employing a large labor force. My lord, only one company was taken over, which is still, my lord, in force. That is Anglo-French Textile Limited, acquisition and transfer of textile undertaking. Then handloom and weaving factory.
But where you write the material resources Anglo-French textiles. I wonder what is Anglo-French textiles. Anyway.
It's a limited company, my lord, but
I thought I can say something here.
land, right to use water, Mysore Palace.
For example, a simple thing is the public distribution, where the farmers have to give levy sugar. The farmers have to part with some paddy to the state so that that is taken.
Distributed equally.
Public distribution under
Public
the
distribution, PDS.
essential.
Yes, sir.
See, that is an example, clear, stark example, so close to the people.
I think the
Rationing of food grains.
learned attorney possibly, my lord, wants to say something. If
No, I was only trying to say about the Anglo-French textiles.
What's that?
I appeared in that matter way back in 1984. And that was a textile mill which is lying close in Pondicherry for about 3 years. After this honorable court intervened, then the government set up a Pondicherry Textile Corporation. That's how it was taken over. And it was a private industry.
Oh. All right. Yes, Mr. Valista.
Lord,
What
then
next?
please come to my lord. I have given 23 examples.
Yes.
This may not be exhaustive. We have tried our best to be, my lord, as exhaustive as possible. There may be few some my lord, legislations left. but public transport system, etc., etc. Lord, now kindly come to Lord PDF 38, para 47. Where, my lord, this honorable bench, my lord, permitted placing of reliance under 39B while defending a particular challenge to an enactment. My lord. That is Bhim Singh ji, my lord, her ladyship, my lord, mentioned.
Case where there is a change in the mindset. 1976 Urban Land Ceiling Act came, and in 1999 it was repealed. That is during the times of 1999 post-liberalization.
Correct.
So 1976 and 1999, that is a stark example of how there is a evolving economic democracy
Yes.
in the country.
Depending upon several internal and external factors. And when I say external means global market, internal factor means, my lord, the production decreasing or increasing, the demand being less or more, etc., etc.
All right.
Lord, I'll just read the highlighted part of Bhim Singh ji, where urban land ceiling laws were under challenge. The whole story, my lord, just above, my lord, just before the highlighted part, the whole story of the legislation, the long gestation of pre-legislative consideration, the brooding presence of Article 39B and C, and the emphasis in Section 23(4) on common good as the guiding factor for distribution point to public purpose, national development, and social justice as the cornerstone of the policy of distribution, it is not and never can be compulsory taking from some private owners to favor by transfer other private owners. My lord, thereafter, my lord, this is all, my lord, last line, last passage, my lord, at page 39. I have already indicated that the postulate underlying the directive principles of Article 39B is that diffusion of ownership and control of material resources of the community is always in public interest, and therefore the state is directed to ensure such distribution equitable thereof as best to subserve the common good, but the priorities prescribed in subsection 1 and 4 of section 23 in regard to distribution of material resources produce contrary results as or results in the opposite direction, inasmuch as private purposes receive precedence over common good. My lord, that is more on the act, my lord. Then, my lord, there is one, my lord, this judgment is, my lord, very Tinsukia electricity, where electricity under 39B was taken under the control of the government. Justice. Lord, there are other judgments where 39B is considered, my lord, for the purpose of testing the validity of a particular legislation, my lord. Now your lordships can consider, my lord, directly coming to 48. My lord, I have given all those judgments where 39B is considered, my lord, but broadly, the view, my lord, which your lordships have taken is this, my lord, that ultimately it must evolve,
This is तुझे
has to
पूछना
be
direct.
left to the parliament, because the parliament is the best judge to decide under present circumstances how the economic growth will take place, whether a particular mode or a particular my lord, format is a better suited format or not. Lord, page 48, Lord, Lord, Coal India, my lord, it is judgment, my lord, by 3 honorable judges, my lord, authored by Justice K.M. Joseph, a very recent judgment, of which, my lord, her ladyship Justice Nagaratna was also, my lord, a part of the bench, where Coal Mines Nationalization Act was considered. Lord, the issue was whether this act would, the Competition Act would apply to Coal India or not in view of Coal Mines Nationalization Act. Well, please see, my lord, the underlined portion.
में ही
So this is per Justice Joseph, my lord.
Which para you are reading?
Lord, para 97, page 48,
97.
para 57 of my note,
97 of the judgment.
97 of the judgment.
Para 57 of your note.
Yes, my lord. Recently, my lord, it starts with that. Recently, the lordship gets me. My lord, Justice Roy gets me.
Yes, yes.
Recently, a 3-judge bench in Coal India Limited versus CCI, that is Competition Commission of India, in the context of applicability of Competition Act to Coal India, which was created under the Coal Mines Nationalization Act, it was hailed as under. The appellants are government companies. They were brought into being in the context of Section 3 and 5 of Nationalization Act. Undoubtedly, they were created to take the place of central government in the matter of supervising, control, and managing the affairs of the mines. Still further, and more importantly, the Nationalization Act itself was intended to achieve the goals in Article 39B of the Constitution. This means that the Nationalization Act contemplated coal to be a material resource and it was to be distributed so as to subserve common good. The exclusive right in regard to the mines, as also the power to manage and supervise the mines, was vested with the first appellant company and its subsidiaries. The ambit of the power is unquestionably wide. We proceed on the basis that the appellants cannot be oblivious to its duty to bear in mind the sublime goal in directive principles, that is distribution, so as to subserve the common good. Lord, please come to, my lord, next, my lord, page 49, para 100 of the judgment. Does your lord, am I with your lordship? The expression common good in Article 39B is a Benthamite sense, involves achieving the highest good of the maximum number of people. The meaning of the words common good may depend upon the times, the felt necessities, the direction that the nation wishes to take in future, the socio-economic condition of the different classes, the legal and fundamental rights, and also the directive principles themselves. As far as the time dictated content of common good goes, it simply means that economics itself, not being bound in chains, but it is a dynamic concept. This, my lord, evolution will be, my lord, with the parliament. Then, my lord, the attainment of common good would be dependent on the appreciation and understanding of a generation as to how economic common good is best achieved. The debate between advantages and disadvantages of pursuing the policy of the state intervention in economic policy, which emasculates private enterprise and competition, has almost reached its end. The advantages of a fearlessly competitive economy have been realized by the nation. There is a backdrop to it. In the year 1991, as ladyship was saying, the nation was, in a manner of speaking, compelled to revisit its economic policy, having regard to the precarious condition of its foreign exchange reserves. The Permit Raj, which involved acute regulation of economic activity by the state with all its attendant evils, cried out for reforms. A slew of highly liberal reforms in 91 set the stage of the nation to make paradigm shift. As discussed in Raghavan Committee report, things moved further in the direction of attaining faster economic growth. The act is a measure which is intended to achieve the same. The role which was envisaged for the public sector company could not permit them to outlive their utility or abuse their unique position. Disinvestment done in a proper manner was perceived as a solution. However, sans disinvestment, state monopolies, public sector companies, and government companies were expected to imbibe the new economic philosophy. The novel idea which permeates the act would stand frustrated. In fact, if state monopolies, government companies, and public sector units are left free to contravene the law, your lordships cannot skip. Kindly come to 120. We agree with the appellants, and as held by this court in state of Karnataka versus Raghunath Reddy, Lord, the judgment which is placed, Ranganath Reddy, my lord, which is placed for your lordship's consideration, that distribution is a word of wide meaning and it is covered by Article 39B of the Constitution. it must be remembered that court had occasion to hold so by way of dealing with the argument that nationalization did not have a nexus with the word distribution. Now, my lords, may kindly come to page 51. Lord, the argument was, I'll just paraphrase my submission, my lord. The argument of the other side was, that was more in the context of Mahada, that preservation of buildings or preservation of natural resources can never be a part of Article 39B. My lord, which, my lord, I have dealt with saying,
Yes.
that intergenerational equity is a concept accepted by our jurisprudence. We preserve many things for the next generation. That is, my lord, what we call intergenerational equity. Please see, my lord, page 51, para 59.
That phrase has been used in this judgment? What
No.
you are saying?
No, not in this judgment. But there are several judgments where intergenerational equity, word, my lord, I'll place it for your lordship's consideration. But that's an accepted position under Indian jurisprudence, that this generation protects and preserves as a trust for the next generation. Yes. Forest, land, natural resources, minerals, etc., etc. And also intergenerational equity is used. But I'll place, my lord, those judgments while highlighting that part. 60. The purpose behind Article 39B, my lord, I'm reading 60, is to secure the ownership and control of a resource in order to distribute it in a manner which results in common good. The argument of the petitioner, therefore, is that preservation of a resource does not amount to common good. Apart from the fact that the said argument is unsustainable owing to the natural wide meaning of the term common good, preservation of any resource is often required in order to further the common good for the people at large and the nation as a whole. For example, the new entrenched principle of intergenerational equity propounded by this honorable court in the context of natural resources provides that resources need to be judicially used in order to ensure that future generations are able to enjoy the fruits of the same. Intergenerational equity requires, in a welfare society and a society based on egalitarian principles, preserving resources, even though they are privately owned, for the common good of the future generations. The constitutional principle of egalitarianism requires that intergenerational equity is adhered to. A balance is required to be struck. Within 63. Intergenerational equity thus requires that present generation utilizes, Lord, that's more repetition, I can skip that one. Lord, I have cited, my lord, two judgments on intergenerational equity. One is state of Himachal Pradesh versus Ganesh Wood Products, and another, my lord, as my learned friend, Lord, Mr. Dwivedi, the younger younger Dwivedi pointed out, my lord, Eklavya, para 65, T.N. Godavarman. Mr. Eklavedi, he is also younger Dwivedi, my lord, but Lord, then consistent precedents on the issue without any conflict. Lord, I will not read it. Your lordships were, Lord, taken through all the judgments where the definition or the interpretation of 39B, which we seek to give respectfully, has been accepted, my lord, be it Ranganatha Reddy or, my lord, Abu Kavur Bhai, etc., etc. Or, my lord, my last point now.
Yes.
Lord, I have already, my lord, respectfully said that the views of Justice Krishna Iyer may perhaps not be relevant, my lord, in the present context. I would put it that way, my lord, and I very respectfully, while respecting the judgment and the view, Lord, respectfully seek to disagree.
Few or some of it?
The sum of them. No, that's, no, not entirely. I have
It
two
will be
small
contrary to
to
your argument.
disagree with Justice Krishna Iyer in the entire. But it was otherwise also contextual. It was in the context of the private property involved in that case, but the discussion became very wide and over encompassing, my lord, which may.
He said that we are not to be construed as having accepted this line of
Correct, correct.
this line of
Correct,
analysis.
And that was in a concurring judgment.
Concurring.
All that was said.
Yes. Lord, page 62. Lord, and this is my last submission on 39B. Lord, my respectful submission is that Mafatlal Industries is not an arbiter. And my lord, I raised that point very seriously. Lord, this is a judgment delivered by 9 honorable judges.
Are you touching?
Lord, page 62, PDF 62. And I have quoted the relevant paragraphs.
Mafatlal, there is only mention in one paragraph.
72.
Ah, that's it.
My 72, my lord.
Your 72. In
I-
Mafatlal also it is in one paragraph.
No, lord, that's the, my lord, that's what is not pointed out. But that's what I want to point out. And my lord, my respectful submission at the cost of repetition, it is not an arbiter. It is a ratio decidendi. My lord, I would urge your lordships to bear 3 factors in mind when a judgment can be said to be arbiter. A, whether the question decided arose for consideration. B, whether arguments were advanced by both the sides. And C, whether the court dealt with cursorily as a passing remark or while dealing with a specific submission made by the counsel. Lord, here, not only the lead judgment, even concurring and dissenting judgment is also, my lord, answering this question. Something which is not, my lord, brought to your lordship's notice. A specific argument was raised by Mr. Parasaran. And from the reading, your lordships, my lord, in my respectful submission will find that in fact court wanted it to become a ratio decidendi. Lord, your lordships have page 62.
Yes.
My para 72 and
Yes.
judgment para 84. My lord, kindly allow me to read this one. Because I want to show point was specifically raised. In this connection, Sri K. Parasaran has rightly emphasized the distinction between the constitutional values obtaining in countries like United States of America, Canada and Australia, or for that matter, United Kingdom, and the values obtaining under our constitution. This discussion, we may reiterate, is also relevant on the nature of the constitutional right to refund or restitution, as it is called. That was the question, my lord, in Mafatlal, flowing from Article 265, referred to in para 71 to 73. Unlike the economically neutral, if not pro-capitalist, constitutions governing those countries, the Indian Constitution has set before itself the goal of justice, social, economic, and political, a total restructuring of our society. The goal being what is set out in Part 4 of the Constitution, and in particular in Article 38 and 39. Indeed, the aforesaid words in the preamble constitute the motto of our Constitution, if we can call it one. Article 38 enjoins upon the state to strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. Article 39 lays down the principles of policy to be followed by the state. It says that the state shall in particular direct its policy towards securing, b, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good, and c, that the operation of the economic system does not result in concentration of wealth and means of production to the common detriment. Refunding the duty paid by a manufacturer or SSE in situations where he himself has not suffered any loss or prejudice is no economic justice. It is very negation of economic justice. By doing so, the state would be conferring an unearned and unjustifiable windfall upon the manufacturing community, thereby contributing to concentration of wealth in a small class of persons which may not be consistent with the common good. The preamble and the aforesaid articles do demand that where a duty cannot be refunded to the real person who have borne the burden for one or the other reason, it is but appropriate that the said amounts are retained by the state for being used for public good. Indeed, even in an economically neutral constitution like the United States of America, such a course has been adopted by the state and upheld by the courts. It would be rather curious, nay, ridiculous, if such a course were held to be bad under our constitution, which speaks of economic and distributive justice, opposes concentration of wealth in few hands, and when a 42nd amendment describe our republic as a socialist republic. Lord, please come to, my lord, at the foot, para 86, that the material resources of the community. Now, my lord, kindly see, they discuss it specifically. 39B is discussed, not as a passing remark. In the first para, the learned judges say this is relevant even for deciding the question of refund. Then they say in para 86 that the material resources of the community are not confined to public resources, but include all resources, natural and man-made, public and privately owned, is repeatedly affirmed by this court, Sri Ranganatha Reddy, etc., etc., etc. Now, my lord, may kindly see para 73, Justice Paripurnan's concurring opinion. Lord, an obiter dicta, in my respectful submission, would be in one judgment. If it is also discussed, a point is also discussed and deliberated and adjudicated upon, even in the concurring judgment, but it can never be an obiter dicta. Obiter dicta is just something said in passing. The question never arose, arguments not made, court never intended to decide that point, and as a passing said something. Here, my lord, after reading the majority, I am, my lord, reading the concurring view of Justice Paripurna. Lord, please see at the foot of page 64. Lord, just, my lord, for 10, 5, 7 line, my lord, from the underlined portion, Sri K. Parasaran, my lord, your lordship gets, my lord. My lord, Justice Paripurnan also is pleased to note the contention of Mr. Parasaran. Sri K. Parasaran brought to our notice the following portion of the preamble and Article 39B and C of the Constitution to contend that Article 265 of the Constitution cannot be construed in a vacuum or isolation, but should be construed in light of the basic principles contained in other parts of the Constitution.
We got the point that you are saying that it was also dealt with by Justice Paripurnan. What happened was, the question was whether if a tax is struck down or if the levy has been held to be illegal, whether there should be a refund. The court said that, look, the manufacturers have not, they've passed on the burden.
Yes, my lord.
They are pertinent, and therefore it will result in unjust enrichment. And therefore, on the one hand, if you say that, well, the manufacturers will be entitled to a refund, all these resources will go into the hands of the manufacturers and promote a concentration of wealth. On the other hand, these resources could be used by the state for the purpose of the common good. And therefore, they said Article 39.
Material resources for the community, stressing it from 39B. Now, my lord, what is not quoted, but I must bring to your lordship's notice, There is a minority view in Mafatlal judgment, my lord. Please have a look at, my lord, volume,
Just give us that, we'll just make a note of it and
Yes.
take your word for it.
my lord, volume 5,
Whose minority view is that?
Justice Sen, my lord.
All right, so volume 5 page,
Volume 5, relevant is, my lord, at page 2914,
para.
paragraph 161.
That's all right, we'll take it that.
There also,
Minority also there.
contention noted and dealt. So, my lord, my respectful submission is, my lord, there is no need, my lord, for, my lord, the bench, my lord, sitting in the combination of 9 honorable judges, my lord, to revisit that point unless it is, my lord, referred to a still larger bench. My lord, last,
Nothing to do with 39.
my lord, now, my lord, I will come to my lord, this is the submission on 39B. Now, my lord, I would wish to assist your lordships on the question of 31C, my lord, according to them, that goes. It's a dead letter. My lord, since that was raised, my lord, subsequently, my note is, my lord, subsequent, my lord, that is 2L. Two capital L.
Two capital L.
L for London. My lord, just for ease of reference.
Looks like the vacation is in your mind, solicitor.
Why, Manoj? No. My lord, your lordships are right, my lord. I could have thought of some, my lord, state, my lord, in India.
L for Lakshadweep.
Yes, my lord, nothing, my lord, in the contextually, well, L for Lakshadweep, not for London. Lord, Lord, for the ease of, my lord, reference, I have taken the liberty of giving different color to 31C. Lord, first part, which is blue in color, and second part, which is red in color. Correct, Manoj? Please see the red part, because this is what is
Red was struck down in Keshwan.
in Keshwanand. That's all, my lord. My lord, one more thing. My lord, I can place it on record and I do wish to place it on record. Lord, so far as validity of 31C, except the red part is concerned, in Keshwanand Bharti, all 8 honorable judges unequivocally upholds it with separate reasons. And I would, my lord, each para I would quote and place it for your lordship's consideration. My lord, the general discussion, my lord, which happened, this is not my argument, my lord, just by way of, my lord, reference, that in Keshwanand Bharti judgment, who decides what and what is ultimately ratio for what proposition, my lord, is not a criticism or a discussion what 31C. 31C, the bench is very clear. 8 honorable judges unequivocally with reasons uphold the validity.
Yes.
Now, your lordships, my lord, kindly see. It is, my lord, now amended, page para 4. Just, my lord, since few days have passed, my lord, just to refresh your lordship's memory, and there is
All
a...
or any principles enshrined in part 4.
Yes, my lord, that is para 4. But, my lord, I would like to again read, my lord, para 4, my lord. 42nd Amendment, see, this is section 4 of the Constitution Amendment Act. Correct, my lord? Please bear that in mind, because my submission is going to be that this amending section has gone.
Yeah.
31C was never under challenge. And if the view propounded by them is accepted by the court, what will be the devastating consequence? I have given illustrations. Lord, for example, tomorrow, one word from the preamble is deleted by way of a constitutional amendment. That constitutional amendment is challenged, and your lordship set aside that amendment, that you could not have deleted economic justice, for example. Would the entire preamble go? That's the argument, my lord. It sounds absurd, but it is that absurd, and I'll show that.
Your argument language is now meaningless.
It becomes completely meaningless.
Yes.
And I have quoted that language, that now if they are right, how 31C would read.
Meaningless totally.
It becomes meaningless.
No, section 4, the amendment of Constitutional Amendment Act, section 4. That section 4 is inserted into the main section, Article 31C. It is inserted,
Substituted.
yes. So it becomes part of Article 31C. It does not have an independent existence.
Correct.
Maybe by a Constitutional Amendment Act, but ultimately it goes into the main Article
Correct, correct,
31C.
correct. So now what was included now no longer exists.
Yes.
And what was there in law has to exist. My lord, that is my respectful submission. Now, my lords may kindly see, Lord, this was challenged, and Lord, first,
So according to you, once section 4, the 42nd amendment is struck down, that necessarily results in the restoration of the position as it existed on the date of the adoption of that provision.
and one more
That's your
thing,
contention.
one more thing, my lord, why? To buttress my submission. Lord Justice, my Lord Justice Y.V. Chandrachud upheld the validity of 31C. My Lord Justice Y.V. Chandrachud authored the judgment of Waman Rao, which challenged the original 31C. But simultaneously, the bench presided by my Lord Justice Chandrachud, who also happened to be authoring judgment in Minerva, I'll show that, was considering post-amendment 31C. So there were two matters simultaneously going on. Waman Rao, 31C as upheld by by Keshwanand Bharti. Second, Minerva Mills, 31C as amended by 42nd Amendment. Both judgments delivered by my Lord Justice Y.V. Chandrachud. And therefore, my Lord, I'll show there is a clear intention of the court. Court is conscious that this is what will be the effect of our judgment, that what was upheld by Keshwanand Bharti now stands revived.
Clear.
Have they said so?
His lordship, pardon? Yes, my lord. My lord, if your lordships are,
You concluded because your second point, no?
this is my second.
So if you can just take us briefly through it.
I'll just take
परिणाम या
a
किस
through it, my
Mr.
lord.
Dwivedi will take it.
Without my lord reading.
So according to you, Waman Rao was dealing with the unamended 30.
Unamended
That's
31.
your contention.
There is no dispute on that. Minerva was dealing with section 4 of amended, section 4 as amended by 42nd Amendment. Both decided by same learned Honorable Chief Justice, my lord, who was the only factor common with Keshwanand Bharti also.
But did Waman Rao deal with the unamended section 31C in respect of a period after
The amendment.
the striking down of the amended 31C?
Yes, yes, my lord.
Or was it dealing with a period prior thereto?
No, after. And therefore it says that what will,
Prior.
No, 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 kindly have a look at, kindly have a look at.
Anyway, but just think, bear it in mind, we don't, you can, but you can go in your own way and then
Judgment
come
gives
back to.
substance.
Lord, the writ petition was 77, but please come to, my lord, page 6, para 6, my lord, page 3.
What's your formulation, Mr. Solicitor, on this?
My lord, my formulation is, my lord, can I show and
Yeah,
formulate?
sure.
Can
You
I
can
show
just
and
quickly,
formulate?
yeah, that's right.
My lord, page 6, my lord, para 6, page 3.
Page 6.
Page, para 6, my lord, page 3, para 6.
Yeah.
My lord, again, I'm sorry, my lord, but the same learned Chief Justice,
Yeah.
Lord Justice Y.V. Chandrachud, why I, Lord, refer to the name, the purpose is that His Lordship was aware that I have dealt with one 31C challenge at 30, as a combination of 13 judges. Waman Rao is 5 judges, unamended. And now I have also heard Minerva Mills, which is post amendment. And therefore, my lord, in that context, please read His Lordship's word. My lord, para 4. In these proceedings, the main challenge now is to the constitutionality of Article 31A, 31B, and unamended Article 31C of the Constitution. Now, my lord, kindly see last line on page 3. We are concerned with Article 30C, 31C, as it stood originally. As it stood originally, but of course, without the concluding part struck down in Keshwanand Bharti. So his lordships were dealing with the first part because second part was struck down by in Keshwanand Bharti. Now, my lord, para 7. Again, my lord, in Waman Rao, my lord, the learned Chief Justice says, 52, that leaves for consideration the challenge to the constitutional validity of unamended Article 31C. As we have stated at the beginning of this judgment, Article 31C was introduced by Constitution 25th Amendment. Initially, it sought to give protection to those laws. Your Lordship can skip.
This is again Waman Rao, no? This quotation.
This is Waman Rao. Then 53. Mr. M.N. Phadke, who led the argument on behalf of the petitioners, built a formidable attack against the virus of Article 31C. But with respect to the learned counsel, the effort is fruitless because the question as regards the validity of Article 31C is no longer res integra. The opening clause of Article 31C.
What was the law? What was the law in question in Waman Rao? That was the Maharashtra Agricultural Ceilings Act?
Yes,
Maharashtra.
agricultural tenancy or see.
There were 32, Article 32 petitions, my lord.
It was the
No, I
agricultural holding.
Agricultural Land, within brackets, Sealing and Holdings Act, 1961. But his lordship decided.
Had to be decided on the basis of the unamended Article 31.
Correct. Therefore,
Because on the date when that law was enacted, unamended Article 31 bench did was they tested the validity of the law with reference to unamended Article 31C. It was not a post Minerva Mills legislation.
it was not.
Ah,
It was not.
we
It
may
was
still
pre-Minerva
still
Mill.
come to the same conclusion, but we must have conceptual clarity that Waman Rao was basically dealing with and clearly an unamended Article 31C.
It says so.
So Waman Rao may not have a bearing on the residue of Article 31C which remains post the decision in Minerva. Waman Rao may not really be conclusive. We will have to address it as a matter of
My lord,
first principle.
My lord, it would have a bearing for the simple reason that both Waman Rao and Minerva Mills were heard together and decided by the same learned judge.
That militates against your submission because it's very clear that in Waman Rao, they were not considering the impact of what will remain after 31C as amended by the 42nd Amendment is struck down. They were not considering that at all. As to whether there would be a revival, whether that would, as a matter of first principle, we may still come to that conclusion, but Waman Rao does not give us a conclusive guidance on that.
Correct, my lord, but
Doesn't
philosophy.
relate to that
It
period.
doesn't relate to the period at all, which we are now dealing with here.
But my lord, kindly, my lord, come to the last part, para 54, because his lordship also deals with 31C on a different ground and upholds it. I understand what is falling from your lordship, my lord, the Chief
I
Justice.
think the substantive answer which you have to the argument of the other side should be something like this. The original provision of 31C, which granted protection or immunity to laws against a challenge, so long as that law implements 39B and C, that original provision was upheld in Keshwanand Bharati,
But-
except for giving finality to the declaration.
Judicial review was
The
open.
judicial review was saved. Now, the widening of the ambit takes place in the 42nd Amendment. When Parliament widened the ambit, the idea was never to replace what was the original content of 31C with a completely new provision, but to expand the ambit to include 31, 39B and C plus all the other provisions.
Correct.
What was held to be objectionable in Minerva Mills was not the original ambit of
Extension.
31C, but the extension, because they could not have said that the original 31C was invalid for the reason that they were bound by Keshwanand Bharati, which they also express. So essentially, according to you, what was struck down was this unlimited power which was given, expansion of 31C to include not merely 39B and C, but the entirety of Part 4 of the Constitution, because the court said then every law which can be sustained on the ground that it implements some provision of the directive principles or the other.
Correct.
So when Minerva Mills strikes down Section 4, you must read the intent of Parliament and the intent of the court. The intent of the court is not to strike down the entirety of 31C.
It was not under challenge.
But the
Only
intent
Section
was
4 was under.
expansion. Now, therefore, to hold according to you that look, even the original 31C is therefore completely obliterated by virtue of the substitution by Section 4, would be in that sense a very formalistic reading of the Constitution.
Another point, my lord.
We are on, is there a more, other than saying it's a formalistic reading of the Constitution, is there a constitutional concept which we can, is there at a conceptual level, can we not?
May I, my lord, assist your lordship on that?
Doctrine of revival applies.
It would not be necessary, my lord. There would not be revival necessary at all. I'll tell your lordship why. Your lordships are aware of the Blackstone doctrine, which is accepted in India by Golaknath downwards. But Blackstone doctrine says that your lordships do not declare the law, your lordships merely validate or invalidate the law. Lord, kindly give me a minute more, my lord, to formulate my submission. Lord, suppose today Parliament amends the law by amending Act number so and so. Section 2 of the amending act amends the law or the Constitution. My principle governing this both, my lord, would be same. After 2 years, your lordships were to strike it
महाराज
down.
कैसी बात कर रहे हैं आप? पत्रकार रहे हैं, नेहा सिंह राठौर लोक गायिका जो कि अब ताबा।
पैसेज फ्रॉम गोलकनाथ।
ठीक है, आप ठीक है, आप नेहा राठौर को नहीं जानते, यही रिएक्शन ही इनफ है कि आप नेहा सिंह राठौर को नहीं जानते।
नेहा सिंह राठौर का नाम आप लोगों ने सुना ही होगा। तो नेहा सिंह राठौर को उत्तर प्रदेश पुलिस ने जो नोटिस थमाया है वो कहीं नहीं तो कहीं गलत किया, और इससे जो है कहीं नहीं तो कहीं सरकार की ही फजीहत होगी।
नेहा सिंह राठौर, कौन सी नेहा सिंह राठौर की बात कर रहे हैं? मैं नहीं जानता।
Substitution goes, meaning thereby the original 31C was always there. That is your declaration, your lordship's declaration. That is, my lord, Blackstone doctrine and accepted in India. it would remain on the statute book.
सवाल बड़ा सिंपल है, हम आपकी बहुत इज्जत करते हैं लेकिन पार्टी
That's his
की
argument.
अखिलेश यादव जो
That
कह
what
दे
will remain on the
वही अंतिम
statute
वर्ड
book.
होगा ना। राजकुमार
Mr.
भाटी जो
That is
कहे
not
वो
the
तो
argument.
अंतिम वर्ड नहीं
31C,
होगा।
as
मैं
it-
इसलिए
No,
पूछ रही
his
हूँ कि
argument
जब
is
देश
what
के
remains on the
प्रधानमंत्री ने आरक्षण
statute
पर बात
book
कर
is
दी,
31C
गृहमंत्री
as
ने आरक्षण
amended.
पर बात कर दी, फिर सारे
It
पार्टियों
is
के
held to
बड़े
be
बड़े नेता ये क्यों
inoperable
कहते फिर रहे हैं
or
कि आएंगे तो संविधान
unenforceable.
खत्म कर देंगे?
I-
फिर क्या
if your
होता है?
lordship
फिर इस
sees
तरह
no
के
black
वीडियोस
If
आते
it
हैं, हम लोग
remains
भरोसा
on the
करने लगते हैं।
statute book according to him,
मैं जो अमित शाह
according
जी
to
के
him, if it
वीडियो
remains on the
आप
statute
जिस
book
पर
but is
चर्चा कर रहे हैं,
rendered
पहली बात तो मैं कहूँ
unenforceable,
किसी के नाम से भी
then
इस
you
तरह की
cannot
फर्जी
have
वीडियो
another
बनाना
provision
एक
to the
अपराध है
contrary
और
on the
इस पे
statute book,
सख्त
which
कार्रवाई होनी चाहिए।
which your
लेकिन
argument
एक
would
कहावत है
entail.
नहीं कि
That's
जो
the,
गड्ढा
that's
दूसरे के लिए
the,
खोदता है
If
उसमें
your
खुद
lordship,
गिरता
I
है।
am Lord not going
माननीय
into
अमित
this
शाह जी
question,
का 22
Lord,
जून
but there
2018
there is
में
one more
वीडियो है,
point.
the better way of
मोबाइल में
perhaps
निकाल लिया, आप चाहेंगे तो मैं
looking
सुनवा
at
भी
it is
दूंगा।
this.
हाँ, ठीक है।
इन्होंने आईटी सेल की
that
मीटिंग ली कोटा में
What
राजस्थान
was
में।
the
आईटी सेल
parliamentary
बीजेपी की
intent
मीटिंग ली
in
और
its
उसमें ये बोला
constitutional
अमित शाह जी
capacity?
ने कि हमारे
The
आईटी
parliamentary
सेल ने
intent
यूपी
was
में
not
एक
to
झूठी
delete
खबर उड़ाई
Article
कि
39B and
अखिलेश
C
यादव ने मुलायम सिंह यादव को थप्पड़
from
मारा
the
और ये
ambit
खुद कह
of
रहे हैं
the
कि
amended
झूठ था,
31C.
लेकिन
The
इससे हमें लाभ
object
बहुत
was
हुआ
to
चुनाव में।
continue
और फिर
with
कहते हैं कभी कभी
39B
ऐसी
and
फर्जी
C
Then
खबरें
expand
भी
it.
चला
and
देनी
then
चाहिए
expand the
जो
ambit.
लोगों का मनोरंजन करती हैं,
Right?
गुदगुदाती हैं, कुछ
The
डराती भी
original
हैं।
provision
ये
was
अमित शाह
upheld
भी
in
सकते
Keshwan
हैं।
Bagchi.
जब पार्टी का
Now,
एक
the
सीनियर
purpose
नेता
of
जो नंबर 2
Parliament in
की
the
हैसियत रखता
42nd
है
Amendment
अपने कार्यकर्ताओं
not
को
being
उपदेश
to
देगा
delete
कि फर्जी
the
खबरें
reference
चलाओ,
to
फर्जी
39B
वीडियो
and C,
चलाओ,
but to
तो कभी ना
expand
कभी
the
तो आपके लिए
ambit
भी
of
उसका
Article
दुरुपयोग होगा। ये
31C,
नींव आपने ही
the
रखी है, माफ करें,
declaration of
मैं फिर भी उसका विरोध करता हूँ
unconstitutionality
जो
of
अमित शाह जी का
Section
वीडियो
4
ठीक है।
लेकिन ये नींव आपने रखी है।
अच्छा,
मैं
अब
reach
आरक्षण पे
out
आता हूँ।
हाँ,
to
आरक्षण
39B
में
and C, but
आरक्षण के
those
मामले में
principles
भारतीय
of
जनता
Part
पार्टी
4
कभी
other
भी
than 39.
उसकी स्थिति स्पष्ट नहीं रही, वो हमेशा विरोध ही रही
And
है अंदर से।
therefore, when
उत्तर
Section
प्रदेश
30, we
में
may then
जो
be
शिक्षक
able to
भर्ती हुई
skirt this
थी,
whole issue of
उसमें
revival
भी
and other
ओबीसी
पार्टी
things
जी, एक मिनट, इसका
by
इस
looking
बयान
at
का
this
क्या मतलब?
particular
अंदर
factual
से वो
context,
विरोधी
this
रही है,
particular
बाहर से कोई
constitutional
विरोधी नहीं।
context,
अंदर
because
से क्या है,
you have
बाहर
to look
से
at
ये तो
that,
किसी
that
व्यक्ति का भापा नहीं
constitutional
जा सकता,
concept,
ऐसा क्या है?
that
मैं भापा ऐसे जाता हूँ।
constitutional
कैसे भापा?
concept
आज
and
वोट के डर से
perspective.
आरपी सिंह जी और
ओबीसी और एससी की भारी संख्या देखते हैं क्योंकि
Listen,
85% ही हैं
is not
ओबीसी एससी
capable of easy resolution. That's why we are
उनके
nine
वोट
of
की वजह
us
से बीजेपी
looking
खुल
at
के
it
नहीं
here.
बोल पाती
Yes,
If it was
अंदर
so
से
simple, we
आरक्षण के
wouldn't be
विरोधी
here assembling in a
But Lord,
parliament.
there is not a judgment.
माइनॉरिटी के विरोधी हैं थोड़ा थोड़ा समय दो प्लीज मुझे चाहे दोबारा मत देना
नहीं 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 बिल्कुल
मैं उदाहरण इसलिए दे रहा हूं सबूत दे रहा हूं उत्तर प्रदेश में जब शिक्षक भर्ती हुई तो ओबीसी के कैंडिडेट ने शिकायत की कि हमारी कॉपियों में फेरबदल किया गया हमें फेल किया गया है
हाँ
तो पहली बात तो कॉपी दिखाने से मना कर दिया
हाँ।
उसमें पैसे लगाए गए 5,000 रुपए जमा करो 5,000 रुपए जमा करके जब
So,
कॉपी
Solicitor,
देंगे
Mr.
गई तो
Andarjana's
जिसके
argument
113
was
नंबर थे उसके 13
that
कर
the
दिए
power
जिसके 120
to
थे उसके 20 कर
repeal
दिए
a
फिर वो
provision
लोग केंद्रीय
is a
पिछड़ा वर्ग
power
आयोग
which
में
is
गए
exclusively
आयोग ने
entrusted
जांच
to
की
the
आयोग ने
legislature.
रिपोर्ट
It is
दी
not a
कि
power
ओबीसी
which
के
is
साथ
conferred
बेईमानी
to
हुई
the
है
court.
यूपी में फिर वो हाई कोर्ट
And the
गए
court cannot
इलाहाबाद
therefore,
हाई कोर्ट ने आदेश
when
दिया
it strikes
कि
down the,
6,800
do
ओबीसी
something
टीचर
which
की
is
भर्ती
really
और की जाए
a power of the
क्योंकि सरकार ने
legislature.
इनके साथ बेईमानी की है
The
वो आज तक
legislature
नहीं
can
हुई
always
है
say, all right,
अब वो
instead of
अभ्यर्थी जो है
all or any
गवर्नर
of the
को पत्र लिख
principles
के
is
कह रहे हैं
substituted
हमें
with the word
इच्छा मृत्यु की
Articles
इजाजत
39B
दी
and
जाए
C.
हम मरना चाहते हैं
That's
क्योंकि
the power of the
सरकार हमारे साथ
legislature.
अन्याय कर रही है
You as a
अब
court
पार्टी
don't have the
न्याय
power
नहीं
to do
देगी।
that. You
जो
can only
सरकार
declare
इतनी
that this is
बेईमानी कर
null and
सकती
void
है,
and therefore
उसके लिए
of
आप क्या कहेंगे
no
आगे
enforceability whatsoever. That is the argument. How would you deal with that argument?
Lord, would it apply? Lord, I'm posing a question to myself.
Member of the Grand Old Party of India, the Congress Party. As Devenderji has said, I served my state for about 2 decades as police officer with the grace of Akalpur Vaikru. And I am sure I am here also with the grace of God. With the blessings of Shri Rahul Gandhi ji, him, Rahul ji, my gratitude to my colleagues in Punjab Congress Party,
I think.
महोदय, मेरा जो आज का विषय है वो है डिमांड टू कंस्टिट्यूट कमेटी टू एग्जामिन द साइड इफेक्ट ऑफ कोविड वैक्सीन्स इन द लाइट ऑफ सडन डेथ्स ऑफ पीपल इन द कंट्री। सभापति महोदय, मैं आज एक ऐसे जरूरी विषय के लिए खड़ा हुआ हूं जिसका ताल्लुक सियासत से नहीं है बल्कि हमारी आपकी जिंदगियों से है। इन दिनों ऐसे ऐसे विजुअल हमारे सामने आ रहे हैं जिन्हें देखकर हम सबको एक ऐसी तबाही के बारे में सोचना शुरू करना होगा जिस पर कोई बात ही नहीं कर रहा है। इस उच्च सदन की जिम्मेदारी है कि ऐसे गंभीर विषय पर यहाँ बात रखी जाए। हम देख रहे
मैं आपको बता दूं, मुझे वो दिन याद आता है जब मेरी माँ की डेड बॉडी पड़ी हुई थी।
Before I formulate, can I only show one paragraph in Minerva?
नरेंद्र मोदी जी का पहला फोन आया और उन्हें सांत्वना दिया कि ओम प्रकाश राजभर, मेरी भी माँ दुनिया में नहीं है, तेरी भी माँ चली गई।
Can I show one?
ईश्वर उनको अपने जगह स्थान दे और आप सेनापति हो, सेनापति धैर्य रखो, लिखो। तो कुछ होता था, हजारों माँ डेली मर रही हैं देश में। लेकिन साथियों, मैं आपसे इतना कहूंगा, जो दर्द आपका है वही दर्द हमारा। हम भी बहुत गरीब परिवार से उठे। आप सोचते होंगे कि हम मंत्री हो गए हैं तो बहुत बड़े मंत्री नहीं हैं। हाँ ठीक है, बाबा साहब डॉक्टर अम्बेडकर जी ने कहा है कि पॉलिटिकल पावर इज द मास्टर की। उस पॉलिटिकल पावर को लेने के लिए हम भाजपा से समझौता किए। हम भारतीय जनता पार्टी के कमल फूल पर नहीं चुनाव लड़ते, हम चुनाव लड़ रहे हैं जो पिछली बार आप लोगों ने
In Minerva means
छोड़ दिया था। जोर से बोलिए, आवाज नहीं आ रही। वह तो निशान है, दूसरा कुछ नहीं है।
In Minerva Mills, please see my lord, page 7, only red portion
Of your note?
of my note. Page 7, the I'll be as fast as I can, my lord. Only red portion your lordship has, my lord?
Yes.
My lord, while comparing the old and the amended, the same learned judge who decided all three, who was a part of all three and my lord, author of the two, the question for consideration in light of this position is whether Section 4 of the 42nd Amendment has brought about a result which is basically and fundamentally different from the one arising under the unamended article. If the amendment does not bring about any such result, its validity shall have to be upheld for the same reasons for which the validity of unamended article was upheld. And thereafter, my lord, the learned judge, my lord, is pleased to say that no, it gives a different result. My lord, therefore, my formulation is this. My lord, the principles of interpretation in case of a statute and the constitution would be different.
Application procedure for e-learners license.
The Parliament, while amending,
Visit www.transport.delhi.gov.in.
13(1)(c),
Click on driving.
never intended to delete or obliterate 39(b) and (c).
Yes.
Therefore, when
Third,
it merely expanded the protection under Article 39 B and C to entire Part 4. What was found fault with was the expansion and not Article 39 B and C.
found fault with in Minerva.
And therefore, the moment Minerva judgment comes, the expansion goes. And not the original 31C. Fifth, my lord. Sixth, my lord. The learned judge, my lord, who decided Waman Rao, and who possibly, my lord, was also in the process of dictating or deciding Minerva, makes a positive declaration, my lord, which is not under challenge.
I think in one part of your statement you are wrong. What I understand is that those days, the judges used to write by hand instead of giving dictation. In fact, copious pages were written so far as the judgments were prepared. So remarkable fortitude and effort that was taken.
Possibly, therefore, the judgments were also not very long and Lord, please come to that declaration, para 9.
That we have seen.
Para
At
16,
the end of Minerva.
para 16.
In other words, you're saying Waman Rao, which came later, has to be read alongside with Minerva Mills.
Because it happens to be decided by the same bench, well, only by even bench.
There is a judicial, what you say, a statement made.
Declaration made. It says, my lord, the declaration says in Minerva Mills that 31C, as upheld in Keshwanand Bharati, stands and only the amended part goes. It could not have been more elaborate or clear or unambiguous than this.
And because it has been upheld,
It could not have been, my lord. Can never be. I'm obliged. That's going to be the submission. Lord, in a statute, there is a possibility of a void being created. But in constitution, there cannot be any constitutional void unless the court is dealing with validity of a constitutional provision which is declared unconstitutional. Lord, there is 31C is not under challenge in Minerva. Well, let us be very clear. Only section 4 of the amending act was challenged.
Right. And that's
Lord,
it, Mr. Now.
Only 5 minutes, my lord. And my lord, there is one judgment, I'll not read, my lord.
Which one is that?
Lord, that is on what happens when Lord, there are several legislative devices for the purpose of amendment. It can be by addition, deletion, substitution. What happens when the legislature chooses the design of substitution? And the Supreme Court has said, my lord, at page 10, para 23, this is my lord last judgment, I'll cite. What happens to substitute? I'll not, my lord, read. Your lordships may, my lord, read it, but it's very, my lord, illustrative, and my lord, it would assist your lordships that if it is substituted and substitution is held invalid, the original remains. Examples on the well, last 5 minutes, my lord, give me last 5 minutes. Lord, please come to page 14. My lord, if your lordships takes the view which the other side, my lord, is arguing, Lord, page 14. Lord, what will be the anomalous situation in a constitution, which is the document of governance of the nation? Lord, I have given some examples. For example, my lord, I have what we have done. The cases where constitutional amendment came by way of substitution. By way of substitution. Suppose that substitution is challenged and that substitution is upheld. Lord, what will be the struck down? What will be the anomalous situation? Please come to page 14. Lord, amendment in the preamble came by 42nd amendment by way of a substitution. Suppose that would have been struck down, the entire preamble goes.
Sounded so real.
By their logic.
It is real.
If their logic is true.
Substituted sovereign democratic republic with sovereign socialist secular democracy.
Substitute, they added.
But the amending act.
Good at that noise.
No, Lord, amending act says substituted. Same language as for section 4.
I can't do it. How can you do that?
It is substituted, my lords.
Substituted the word. They didn't say add socialist, secular after sovereign and before democratic. They substituted.
Page 3966, it's on record.
Well, we got it here.
Volume 4, 3966.
The footnote in Mr. Shankarnaran's.
Yes. So the entire preamble goes by their logic. Now, my lord, amendment.
That is not the import of their argument.
No, but that line goes. My lord, that
Everything goes in.
that is.
Everything goes in.
Then everything. Your lordships are right.
Everything
Literally everything goes, my lord. If their argument is accepted. My lord, I'm sorry, my lord, for giving this illustration. Lord, giving this illustration, the salaries of judges are also by way of amendment by substitution. There cannot be a constitutional vacuum. There can be a statutory vacuum. That's the contention.
The word.
I mean, in another way, sorry.
Earlier it was sovereign democratic republic. Now socialist and secular were added between sovereign and democratic republic.
Substitute. So the amending act uses.
We are taking out this word and we are putting this. And in 42nd Amendment.
Correct, my lord, but I am on substitution, my lord, that if it is substituted part goes. Suppose your lordships were to accept the challenge to those new additions, then only substituted part goes, the entire part doesn't go.
Why it is second part directly affects us because that deals with our salaries.
Well, therefore I say kindly pardon me for this example, but salaries are always, my lord, amended by way of substitution. So there would be a vacuum, my lord. My lord, there can be a statutory vacuum. There cannot be a constitutional vacuum. No, that's the respectful.
But please rest assured, if you increase the salary, we will not strike it down.
No.
And it cannot be decreased.
No, will.
And it cannot be decreased. Service condition 284 shall be substituted.
No, that's all. And 4 and 2 are peri materia. And now, my lord, only last line, my lord, para 20. Please see page 20. How section 31C would look like or would exist if their argument is right. Para page 20. Saving of laws, my lord, your lordship gets, my lord.
Those all or any of the principles will go completely. It will...
Notwithstanding anything contained in so and so, no law giving effect to the policy of the state towards securing blank, blank, blank shall be deemed to be void.
No, according to Mr. Andarina, those words will still remain on the statute book, but they will be unenforceable. They don't go. That's the argument.
How do we reconcile, my lord, preamble and large number of substitutions? Well, there are some inclusions also. By way of amendment, something is included. But we have examined the substitutions. And please examine, my lord, if that, my lord, kindly, my lord, your lordships are aware, my lord, when privy purses were taken away. Privy purses were taken away by way of a constitutional amendment. Because constitution promised that we would be giving these privy purses. My lord, they failed. But suppose they would have succeeded. Kindly, my lord, examine. This is a, my lord, glaring. I'm sorry, my lord. My lord, this is my last example, but a glaring example. After, my lord.
By and large, we got
only last example, which I feel, my lord, is a glaring. This argument would put the court in a little helpless position. That's what I want to show. That's what I want to show. Therefore, this interpretation should be avoided. My lord, in original constitution, there was a my lord, article which gave certain assurances to the princely states by way of princely purses. My lord, the government of the day decided that we should do away with princely purses. Princely purses. Privy purses. Lord, that is Article 360, whatever. Lord, that deletion was challenged. Correct? Deletion was challenged. Ultimately, the challenge failed. But suppose the challenge would have been allowed by your lordships.
Was allowed. Because it was by order.
By order, it was executed.
That these rulers will be derecognized. That's why they said you can't do it. Then
But
Parliament
you can't do it you can't do it in an executive action. Raghunath Rao. But thereafter, the court said first that you can't do it by an executive order, you have to have a constitutional amendment. Now, please see, my lord, suppose that challenge would have been successful. The article goes, your lordships cannot enact the law. That letter would remain that they would get privy purses. If somebody were to come before your lordship will have to say, if they are right, that sorry, we have struck down the deletion, but we can't do anything unless the parliament re-enacts. But that cannot be the intention. So Mr. Salve wanted to say something because he appeared in both Waman Rao and
Mr.
Minerva,
Salve?
Lord, if your lordships can.
Yes, my lord, I just want 10 minutes, my lord, and I'll finish at lunch. By the clock.
Before my learned friend starts, just one small interjection, if Lord will permit me.
Mr. Attorney will come back to you after lunch because Mr. Salve only wants 10 minutes. So that
No, fair enough. I thought after lunch I may have some. I just want to say I prepared a note.
Right.
I'm not going to ask you to read that note. That note is on
License
first
related.
principles and entirely addressing this question of revival. So I just want to say, you Lord, kindly read that. Probably some light may be available in that note.
Just ask your junior to give us the volume number for your note. So
I
that we
will
can-
do that. I'll do that. I'll do that.
Yes, line, my lord. The judgment in Minerva and Waman Rao was delivered on the same day.
9th May 80. 9th May 80.
No, my lord, I just wanted to add two things.
Yes, Mr. Salve.
My lord, the fallacy lies in
Operative
applying-
order.
Operative portion.
Operative order.
Yes, operative one. My lord, the fallacy lies in applying rules of statutory interpretation to reading judgments of the court, molding relief in constitutional matters. My lord, Article 368's construction that there is a limit on the power of Parliament to amend the Constitution is one of the most perhaps dramatic developments of constitutional law jurisprudence in the world. How that power is exercised and what is the consequence of that power, only your lordships can say. So reading rules of substitution, interpretation, repeal are, my lord, completely misplaced. And my respectful submission is a declaration by the court doesn't repeal a law. A declaration by the court results in the law being stillborn.
जिसका नाम है रितोम सिंह, उसको फेक वीडियो के मामले में गिरफ्तार किया है। गृह मंत्री का जिसने फर्जी वीडियो, झूठा वीडियो बनाकर डाला था, उसको
The
गिरफ्तार कर लिया
declaration
है।
given in
इस समय की
paragraph
बहुत बड़ी खबर है।
75 of
हेमंत
Minerva
बिस्वा शर्मा
Mills.
ने इसकी खुद जानकारी दी है। इस समय की बहुत बड़ी खबर है और मैं आपको बता रहा हूं, मेरी खुद बहुत हाई लेवल होम मिनिस्ट्री के सोर्सेज से भी बात हुई है। सरकार की बहुत
Relates
नजर
to
है। अगर कोई
section
इस तरह के
4,
फर्जी वीडियो को अपने
not
सोशल मीडिया
Article
हैंडल पे
31.
डालता है और इन फर्जी वीडियो को व्हाट्सएप से शेयर करता है, उनके ऊपर कार्रवाई करी जाएगी। क्योंकि झूठा वीडियो वाकई अगर, क्योंकि ये समाज के अंदर द्वेष पैदा करने की बात है। चुनाव से ऐन पहले अगर ये ऐसा होता है तो इससे समाज में वैमनस्य पैदा होगा, नफरत की खाई बढ़ेगी। इसलिए बहुत जरूरी है कि इस तरह के वीडियोस को रोका जाए, क्योंकि ये समाज के लिए अच्छा नहीं है। नॉट ओनली फॉर इलेक्शन,
This is very important.
समाज के लिए बहुत गलत है, बहुत
And
खराब प्रथा है।
Article
और ऐसा कोई भी
4
अगर
said,
पॉलिटिकल पार्टी करती है तो बहुत गलत करती है।
Section
ये
4.
अपने वोटर्स के साथ भी एक
Section
तरह से
4
धोखा है।
said,
अपनी पार्टी वर्कर्स के साथ तक
in Article
ये सामान्य घटना नहीं
31C,
है। मैं फिर
for
कहता
the
हूं इस बात को,
following
ये
words,
सामान्य
substitute the following words. Minerva Mills said, if we allow this substitution, then 31C, which was upheld in case Waman, is radically changed and the changed 31C, this change in 31C violates the basic structure because it dismantles the trilogy of rights, 14, 19, and 21.
That's correct.
And the words in paragraph 75, your lordship has read it over and over again, quoting the operative decretal order which had first been pronounced. Was section 4 is beyond the amending power of Parliament and is void. Let's stop there. The since doesn't matter. If section 4 is void, it is as though it was never enacted. Where is the question, my lord, of saying parts of section 4? It doesn't say that part of section 4. Your lordship's declaration, decretal declaration is section 4 of the Constitution Amendment Act is beyond amending power of Parliament and is void. If 4 is void, and that's your lordship's declaration, then you scrub out 4 from the statute book. 4 was stillborn. It never breathed life. Where is the question of parts of 31C going away and parts of 31C remaining? The whole of 4 was void. That's the short answer to this, my lord. And it is a nostalgic moment for me. It's a nostalgic moment for me, my lord. That's why when the Solicitor General asked me to assist, I was trying to hold fort, my lord, as Solicitor General for the state of Maharashtra, when the redoubtable Mr. Nariman argued this point first, before 5 judges. And we were first called upon to say, is there a 31C? Then, my lord, we argued 31C. Then he argued the main point about the challenge. And immediately I was called upon. I said, I rely on 31B and 39B and C. When, if I remember correctly, sitting on the right side, Mr. Justice M.B. Shah said, oh, but this resources means government's resources, not private resources. So I cited Sanjeev Kok. That's how that issue got referred to 7. Before 7, a bench headed by Mr. Justice Barucha. I cited Mafatlal. That's how it got referred to 9. The issue was always about 39B and C. If this point had to succeed, but the second issue didn't arise. If this point had succeeded, there was no question of reference. 5 judges would have said there is no 39B and C on the statute book. We have already held it violates Article 14. End of the road. So, my lord, I submit this point it's a non-point, with great respect. One cannot superimpose rules you apply for statutory interpretation and working the General Clauses Act to Article 368 and the power of this court to determine the contours of 368. But what your lordships do is, when your lordships say it is beyond amending power, suppose, my lord, this bill had been passed by Parliament ordinarily present and voting, what would have been the result? Your lordship would have said nothing has been done. If a state assembly passed a law saying we repeal 39B and C, would your lordship take cognizance of it? You won't. So, my lord, when your lordship says it violates 368, don't take cognizance of this section 4. Life goes on. That's the result, my lord. That's, I would submit, has to be the approach in these matters.
Thank you, Mr. Zare. Thank you.
Deeply obliged.
Thank you, sir. We'll come back after lunch and hear Mr. Dwivedi now.
Oh, my lord, what? Yes, my lord.
And of course, this is in lighter vein. You are giving, voicing concern about substitution of the preamble and whether preamble, if the argument of the other side is to be accepted, whether the preamble would exist. In that case, we'll have a constitution without the preamble, meaning thereby a constitution which will simply amble.
Your Lordship. And if preamble goes, my lord, nothing remains, in fact, my lord. As my Lord Justice Dhulia said, then